All right, so thank you very much for tuning in. All right, so as soon as you'd file something like that, you can, bet your bottom dollar that they're going to file a motion for summary judgment, right? And this would be, I was thinking, let's say for example, the chances of this motion being, granted, I was predicting before I did the analysis that, oh yeah, for sure they're going to. Because Canada's a lost cause or whatever, but that was for sure they're going to win. But then I got to analyzing it, and I was like, well, probably not. Right? They're probably not going to. That means that what? Um, let's say for example, that we were able to, get this, the whole thing is considered justiciable, right? Or, let's say for example, it is, certified as a class action, and we get to the discovery phase, and all this stuff, right? The discovery is basically, the whole point of this whole thing, right? You'll be able to actually put these doctors on the stand and not on the witness stand, but in a special room there, and record everything that they're saying, and ask them some real questions, and subpoena these kinds of documents and all this stuff. For example, you'd get a lot of information. But anyway, the whole point about all this stuff is, would we even win, right? So let's say for example, you probably get an automatic loss in the Supreme Court, and then the appeals would be just would just be, um, if we didn't get there, and then and that the Supreme Court of Canada would likely not even take the case. If they were to take the case, the likelihood of success is low, right? So, but that's how this whole machine keeps going. All right, so the likelihood of a defendant's motion for summary judgment be granted in a declaratory relief. Declaratory relief, declaratory. I think the right pronunciation there is declaratory. Declaratory. Declaratory relief action depends on several key factors, especially in a context like this where the case touches on morally and emotionally loaded issues, reproductive laws, familial relationships, and medical decisions. Here's a breakdown of the legal landscape in Nova Scotia or Canada in general for such cases. So the summary judgment standards, right? This is the thing that basically, let's say for example, you file any lawsuit, and there's a just throw this whole lawsuit in the garbage right now, right? Before even getting into the facts. That's basically, this happens all the time, right? It's a motion for summary judgment. You can expect that they will file this motion for summary judgment. That means, just throw the whole. They're going to ask the judge. What are they asking the judge to do? They're asking the judge to throw the whole case in the garbage right now, right? That's what they're basically doing, right? So in Nova Scotia, under the civil procedure rules, a motion for summary judgment will be granted only if there is no genuine issue for trial. So the burden is on the moving party, which would be the defendant, Dr. Michelle Dow, to show that there's no merit to the claim. There's no merit to the claim, or there's no genuine issue requiring a trial. So whose burden is it to actually prove that? It's to the doctors, the lawyers representing the so-called doctor. I don't believe she's a doctor, but whatever. So the court will consider affidavits, documents, and transcripts, and they'll try to determine if they can fairly and justly resolve the dispute without a trial. Right. So if your case raises novel and unsettled legal questions or factual disputes around professional negligence, ethical obligations, or medical interpretation, a summary judgment is unlikely to be granted. Right. So that's really not where I was, like my presumption would be for sure that, this kind of thing, with the only reason I would assume that is because, they're so pro-abortion, right? That's where I was going. It was not, just an elementary presumption. It wasn't anything that I analyzed. But as I'm analyzing this, you know, any motion for summary judgment would be close to being, vexatious. How can these guys just file any kind of motion like that and not have it be considered vexatious, right? What do you mean there's no merit, right? What do you mean that there's no merit? Of course there's a merit. You're here, you're here. First of all, changing the definition of a pregnancy, like, that's nonsense, right? That's absolute foolishness. You know what embryology says, and number two. you're here lying to the patients, the patients, or I don't know if it's a patient or if it's a doctor, but you're here lying to these ladies, saying that these birth control pills prevent pregnancy. When of course, there's a merit to this claim. Of course, you're lying to these women. Yeah, basically, they're in trust. They're entrusted in your word that these will prevent pregnancy. If I take these pills and I engage in extramarital or premarital heterosexual intercourse, right? Sexual intercourse, I will not, quote unquote, get pregnant. Okay, so what is getting pregnant? I mean, that means literally getting a baby in your belly. So what do these pills do? They do not prevent the conception. The ovaries will ovulate, right? There's an oocyte there. The oocyte is, of course, what is known as the egg. We are not chickens; we're humans. These are called oocytes, right? These are called oocytes, and they will they will exit from the ovary, right? And then the sperm will be able to reach, despite these prevention methods, they will still be able to reach the oocyte, and then the baby will be conceived. The zygotic genome activation will be successful. The baby boy, baby girl is, alive, and then the baby boy, baby girl at the very later stage, a very natural and later stage of development, which is the implantation, will die, and that is an incredible tragedy because of Dr. Michel Dow's negligence. Is it negligence? You know this, but you just do it anyway. This is bordering on a crime. Well, it certainly is a crime. It certainly is a crime. She knows that this doesn't prevent pregnancy, right? She knows that the embryo and the sperm meeting together, and the sperm will be the oocyte will allow the penetration of the will allow the sperm to be penetrated. The oocyte will consciously choose which sperm is better, and that she knows all that. She knows that a blastocyst failed to implant is not a legitimate prevention of pregnancy. It really is not. This is the death, a violent death of an individual, a baby boy, baby girl. Right. All right. So then I was like, oh, so let's say, for example, they file this summary judgment. Is that going to be successful? Of course, they're going to be successful. And then I can't get to discovery. What did I do all this for? But no, let's say, for example, no. Let's say, for example, I would be successful. I don't believe I'm going to be successful at trial, but I believe that I will be able to get into discovery, which is the whole point of this whole thing. The whole point is winning, of course, any kind of trial, but you're not going to be able to win. How can you win, right? Discovery is going to be as good as I believe that I'm going to be able to get, and I believe that I can, legitimately get to discovery. All right, declaratory relief, a shield against summary dismissal. Declaratory relief is typically forward-looking, not necessarily seeking damages. You are asking the court to interpret the law or determine legal rights, which often requires a full hearing, especially if the subject matter is publicly important. For example, the birth control's effects, fetal right, medical ethics. Does the young lady, 15, 16, 17-year-old lady, is she physically capable of consent? Is her brain development enough that she's able to understand, number one, not only the fact that the baby boy, baby girl will die, at the very later stage of development, which the baby boy is conceived, right? These birth control pills do not prevent that. And does she understand that these birth control pills will kill a baby? And can she legally, consent to that? Is that even possible? And I would submit that it's not. The brain development is not adequate at that stage. She's only 16 years old. Now, her fertility certainly is, right? It's not an illness that needs medical correction. The fertility is certainly, 16-year-old girls, can get pregnant by, dancing with a boy in high school, right? That's how fertile they are. Let's not beat around the bush, right? It's really, really, this is not being dealt with in the correct way at all, right? What about keeping your knickers on? Ever think about that? All right, let's continue. So the minors, and let's add that here, minor. Let's add this one. The issue about the minor informed consent thing there. All right, so number two here, the applicant is seeking for clarity on legal rights or status, and there's an arguable level of constitutional question. Um, sorry, there's an arguable legal or constitutional question. Sure, Canadian courts are often reluctant to dismiss such applications prematurely unless they're obviously frivolous or moot. All right, so is this frivolous? Is this a frivolous case? Well, no, the baby is there is a death, right? So that is not frivolous. It's certainly not. Right? Is it moot? Well, this is happening all the time, right? So it's not moot. Here's what's vexatious here is the motion for summary judgment. That is, I was driving today and I was like, hey man, let's say for example that there would be a motion for summary judgment. Why are costs not being awarded, for a vexatious motion such as a motion for summary judgment? Why would costs not be awarded for the dismissal of a motion? Such as it's just so very very vexatious, right? This is certainly, there are merits. There's certainly a genuine issue. It's not frivolous or moot, so then, I do believe that this will be able to get to the stage of discovery, right? So where your claim could be vulnerable, summary judgment might be granted if your pleadings don't establish a justiciable issue, which we did do a video about that just a few minutes ago. I did a video about that. If the court has no legal basis to rule. So we did so this is the justiciable issue. We did that, and I do believe that it does establish that there is a tangible justiciable issue here. So the facts are undisputed and unfavorable to your claim. The relief sought is an academic moot or not grounded in law. So, for example, if you ask for a declaration that contradict established medical or constitutional law without sufficient expert support, right? Well, it does certainly contradict, the gynecology's definition of pregnancy, right? Because they're going to all of a sudden arbitrarily claim that, implantation is the starting of pregnancy. Well, that's nonsense, right? So, should we have to have an embryologist? Who's the embryologist that's going to come and testify? What? Oh, nonsense. We already know this to be the case, but we need some PhD, I don't know, some embryologist or whatever, say, well, it kind of does, the zygotic genome activation kind of does happen there. It's after the conception there's the morula stage, and then there's the we know this already. Why do we need an embryologist anyway? So how to protect against summary dismissal? Draft a clear, justiciable, pleading. Show exactly what legal right or duty you want clarified, and raise constitutional or charter dimensions, if applicable, and support your claim with evidence. Right? Medical records, scholarly articles, expert affidavits, embryologists, or bioethicists. Argue that there's public interest involved, not just a personal grievance, right? That would be the class action certification for, well, if it could be certified as a class action for the purposes of a declaratory relief case, right? And certainly rare, but it is certainly possible. There's nothing that says you can't do it, right? So, and frame the case as one that needs clarity from the courts due to the potential for future harm or legal confusion, right? So very, very good, right? So what are the chances of a motion for summary judgment being granted? Oh, at first I was like, oh, it's for sure going to be granted, and we're not going to be able to get to discovery. But now that I look at it, I mean, could we actually get to discovery, and can we grill, Dr. Michelle Dash? She blocked me on the social media, and I can't call her because she, refuses to give me her phone number. So this would be the way that I'd be like to able to to really, put her in the hot seat and say, what are you doing? What are you literally doing, right? And I expect I do expect a loss at the trial, right? So it's certainly, I mean, it's not like I'm wrong, right? I'm certainly not going to win a trial, right? Maybe I win, but I'm probably not. But certainly expecting a loss at a trial, right? In a trial setting, right? How can a country such as Canada that's so far gone, and doesn't protect its, baby boys or baby girls from the conception, how can we win in this type of a court? So then, where's the authority, right? The authority is certainly not in a court setting like that, because here's they're disagreeing with medical science. Right? Whatever. I'll see you. Bye bye.